In California, the minimum automobile liability policy that you're required to have under California law is a $15,000 coverage. What that means is there's $15,000 in liability coverage available to someone else should you be at fault and cause an accident. Now, the problem with the $15,000 minimum liability policy law is that in serious injury cases, in cases of death, in cases of paralysis, major head trauma from automobile accidents, $15,000 isn't even going to cover the first day of medical care and treatment that the injured party has sustained. So when we have these cases come into our office and we sit down and explain to our clients the problems with a minimum policy case, and many times you don't know what the policy is when you're retained. All you have is a police report, if that. There's a certain way to handle these situations, and that's what I want to talk to you a little bit about today. If we have a situation with a client with a major catastrophic injury, and we're able to confirm through the other side's insurance company that the only insurance coverage that other party has is a minimum $15,000 policy, what we found is some law firms will immediately settle the case for the $15,000, and they're done. They'll wash their hands of the file and move on to the next case. Let me tell you what we do, and it's a little bit different. It's got the client's best interest in mind. It's got your best interest in mind. What we do is we have a professional service independently investigate what assets, if any, the responsible driver has above and beyond any insurance policy liability coverage. We look at bank accounts, we look at real property, we look at homes, we look at financial portfolios, we look at beneficiary interest in trust and wills. The person that caused the accident, does he or she have any other assets that we can tap into to help compensate you for your injuries? And in many instances the answer is yes, but it just takes a little bit of elbow grease and frankly some advanced expenses that we'll advance on behalf of the client to get the answers to these questions, and we advance the expenses to hire the companies to get these answers for us. We had one situation where, just recently, where a gentleman lost his finger because of a dog bite situation. And here in California, there's strict liability, and the other party was responsible. There was no insurance to cover the dog bite injury, and to make a real long story short, we filed and served a lawsuit. The owner of the dog had a ton of equity in her home, and we were able, in exchange for settling the case, we were able to get the owner of the dog to drop a personal check off at our office for something like $330,000 to take care of our client's injuries and damages. The reason we didn't settle the case for quite a bit less that was offered earlier in the case was because doing this background asset check, we found out about this house and we found out about the equity in the house. And so we sat tight on our settlement demands and on our insistence on making sure our client was adequately compensated. In other instances, we will use third-party resources to do a nationwide and, in some cases, an international asset background search. We try to find out whether or not these people have anything offshore, whether or not they own real estate in a different state or a different country. Something that has value that we can force the other side to either sell or use as collateral for a loan to pay a settlement to our client on a catastrophic injury or wrongful death case. It's an area of law that a lot of lawyers will not spend the time to pursue, but it's something that needs to be done if you're going to place the client's best interest first. Another thing we do that's not quite as complicated, but it's very effective, is if we're dealing with a minimum policy, many times we have a declaration that we'll ask the defendant to fill out. The declaration asks the defendant to declare under penalty of perjury in the state of California all of his or her assets, all of his or her insurance coverage, whether or not she was in the scope and course of employment at the time of the accident, and this way if we rely upon this written document, basically confirming either there's a minimum policy or yes, there's a supplemental liability policy, but it's only X amount of dollars. If we rely upon that written representation and settle the case, and then later on down the line, 6 months later, a year later, we find that that person was lying to us about what he or she had or didn't have, we can then go into court and arguing fraud, we can have the case reopened, and that will allow our clients additional avenues towards settlement proceeds. So we use these asset and insurance liability declarations and disclosures weekly when we're settling cases with the other side, so that we force the other side to lay out all this information so that our client can make an intelligent decision about what he or she wants to do next. A caveat to that is sometimes we found defense attorneys telling us that there's only X amount of dollars in a liability policy, and that's all the defense attorney is aware of. What they don't know is that their client has an additional insurance policy with another insurance company that the client conveniently is not telling the defense attorney about. So, by requiring this client to fill out the documents I've discussed with you, it sometimes educates the defense attorney about what additional insurance liability policies are available, what additional benefits are available, and the net result to our client can be in a substantial increase in the settlement that we're able to obtain on their behalf in a case. So it's kind of complicated stuff, but it's important for you, the consumer, to know that there are many things that need to be done before you ever contemplate settling a case for the minimum policy limits. If you have any questions, give us a call. Our contact information is at our website, www.jacksonwilson.com. Once again, this is Mitch Jackson. It's been a pleasure, and please remember to make today your masterpiece.